Now, before the break, we showed you how the Chauvin trial is playing out here and how prosecutors and the defense seem to be forming their respective cases. I want to bring in our guest to analyze what he's seeing and where he believes this could be heading. Tom Luzio, former prosecutor at the Westchester County DA's office and also one-time assistant deputy attorney general for the state of New York. Tom, thanks for your time. You know, I got the law enforcement perspective. Chief Banks, who was the former top uniform officer in New York, he told me not only what he saw was not in any book, police protocol here in terms of how Officer Chauvin should have handled that case, but moreover, not only was it not in training, but cops, including supervisors, commanders that he spoke to, he couldn't find any of them who feel that Chauvin was in the right or understandable what he did. From your perspective, because there's a fraternity of sorts with former prosecutors, from the folks you've spoken to, the case laid out to this point by the prosecution and how damning both the testimony and the visual evidence you've seen to this point, is there a growing consensus that the defense is in trouble here?
Certainly think the defense is in trouble here. It's they've got to somehow show that there was either some lack of proper training on his part, that this use of force was reasonable, or and it just not adding up to this point at all, Richard. I mean, even if it added up for the first few minutes of the apprehension and the handcuffing and thinking that Chauvin's knee was on Floyd's shoulder, at some point, 3 minutes, 4 minutes, you pick the moment, but there's been no real response to those last 5 minutes, 6 minutes. There's just no response whatsoever that I've seen.
Put yourself in the prosecution. Do you want the jury to focus most of all that 9.5 minutes is an eternity here and they could see for themselves? Or to me, when you have a dispatcher calling in saying, you got a problem here, call me a snitch if you will, but it don't look right. Or you have an off-duty firefighter who's trying to do or offering to do CPR on the guy to try and see if she can find a pulse or to keep him alive, and they're refused, let alone seemingly everybody on the sidewalk seeing what we saw in the video, which is this is bad going to worse. So what's the one thing you want that jury, when they go to deliberate, to take from them from what they saw in that video?
The universal question that is even transcends this case is, no matter what happened prior to this arrest, no matter whether it was a person being arrested for murder or shoplifting, once he's in custody, once George Floyd was in Derek Chauvin's custody, it was George Floyd's safety that became the responsibility of the Minneapolis PD. And beyond everything else, he was neglectful of that responsibility. Certainly, they believe that the neck to the knee was the cause of his, the knee to the neck was the cause of his death, and that there was the opioid use is not a contributing factor. But certainly that was at some point became intentional. But the fact that that was his responsibility and he neglected it and still kept his knee on George Floyd's neck is just unconscionable.
How does it work, Tom? I know each case is different and each piece of evidence uniquely examined by the judge, but how does it get decided before that Memorial Day, obviously tragic incident? What gets in terms of evidence and what doesn't from their biographies beforehand? The judges said that, hey, a year ago, Floyd was stopped with eerie similarities, drugs also, and that's going to be presented to the audience. But Chauvin's got a jacket himself of prior uses of force here and some complaints that were issued against him. As I understand it, that won't be entered. Is there a rule of thumb? What's relevant, what's not, what gets to be shared with the jury and what doesn't?
Sure. So no doubt, especially if Chauvin knew a little bit about that prior arrest where Floyd was combative, it's a small thing in his defense. But as I understand Chauvin's career, there were 18 prior complaints or so, give or take. And So, you know, law enforcement, my whole career, I saw a lot of active cops get hit with a lot of complaints that were not founded. I care, first and foremost, I care about the founded complaints, which, from my understanding, there were 4. So that, first of all, it's hard for me to argue against those other 14 complaints that turned out to be unfounded without really looking through every single one in detail, but unlikely to come in. Now, down to the 4, what's the relevance to this case? So if Chauvin had, again, I'm making this up, so I don't know which complaint came in, and I don't know what the complaints are against him, but let's say he'd taken $25 out of the defendant's wallet after arrest. If you analyze that, does that really make sense that that has anything to do with this trial, an assault and a murder and in custody? Probably not. Did he lie about something on a prior arrest? Well, that might be different. Now, that might be a complaint that would come in because it's relevant. As I understand it, he may have said that he thought his knee was on the shoulder, not the neck. That's clearly shown not to be true. And so if he had lied and that was the substance of a prior complaint, then it would seem relevant. And then, of course, if there was anything eerily similar to this, where he had used excessive force on prior occasion, that might be relevant and connected to how he handled this situation.
Tom, what's it like bringing a criminal case against a cop in that, you know, I've heard some people say, hey, if this was a regular person, this would be handled different. It's not a regular person. We ask a lot of law enforcement who put them in real difficult situations, but it seems to me that a jury, when they're looking at an officer, they may have different expectations about what should or shouldn't be expected from a person on the job. How do you handle that when you're laying out and trying to make it clear where the standards of acceptable behavior and not, and where that line is with those 12 jurors?
So with those 12 jurors in this case, I'd have to say, stick to the facts of this case. What you saw, you're not an expert, right? But we're gonna show you what we have to prove to convict this man, forget that he's a cop, of second-degree unintentional murder or third-degree murder in Minnesota. And so my summation might touch on it a bit in terms of, especially in terms of what Lieutenant Zimmerman testified about, is this is not our policy. This is not what cops do. This is not how we train our men. So I'm going to mention that, but a lot of my summation has to do with don't be clouded by this. This is another human being. Yes, he may have been in a tough spot, but at the end of the day, did he cause George Floyd's death while he was committing a felony? And that knee to the neck for those last 5-6 minutes, I'm focusing on that first and foremost.
Tom Luzio, I really appreciate a few minutes with you. Thank you so much.
Thank you, Richard.
All right, folks, we come back. We're going to pivot to the world of politics, and it is looking like Republicans could be on the wrong side of history, and I say that again. Majority of voters, they like the new stimulus plan and also Biden's infrastructure proposal. But the question is, what's McConnell going to do? Right now, he and every Republican is opposed to the idea. After the break, I'm going to show you why that's not the only headwind the GOP is facing.